afternoon. Today I'll be announcing our filing decisions in two cases that have received quite a bit of attention from the public and the media. I'll start out by noting that much of the coverage of these cases has included incorrect, incomplete, and exaggerated information that has resulted in the public having an inaccurate understanding of the events of June 14th and June 15th. During the past 2 weeks, my office has conducted a thorough and in-depth investigation that included interviews, evidence gathering, search warrants, and expert analysis of this very complex matter. Our investigation has revealed the following. Joseph Irby and Courtney Irby are a married couple currently going through a divorce. This divorce action has been pending since January 2019. During their marriage, both husband and wife have filed temporary injunctions against each other. Mrs. Irby has filed 2 injunctions. One was dismissed for lack of evidence by a judge, and one is currently pending. While it is common for a divorce to be a tumultuous experience for everyone involved, the Irby divorce has been particularly acrimonious. They have been living apart in separate residences for quite a while. Each party has vacated the marital residence and established their own homes. Throughout their separation, they have continued to have frequent arguments, confrontations, and significant disagreements about money, property, and their children. There is competent evidence that supports that both Mr. and Mrs. Irby contributed to the ongoing strife. The morning of June 14th started like many others in recent history for the Irbys. They had an argument by text message on this day. Most of the text messages were from Mr. Irby and some phone calls to Mrs. Irby regarding one of their children and the fact that Mrs. Irby was having coffee with a friend. Mrs. Irby became so upset with Mr. Irby that she went to the Lakeland Police Department and attempted to have him charged with a crime. She told the officer that Mr. Irby had, quote, a ton of arrests for drugs, resisting with violence, and other charges. This was untrue. A quick check of Mr. Irby's record confirmed that Mrs. Irby was incorrect in what she was telling the Lakeland police officer. Unable to get him charged with the crime, Mrs. Irby drove to Bartow, where one of her children was attending a summer camp. The major dispute between the parties that morning was the fact that the child did not have a doll that she needed for camp that day. Mrs. Irby had the doll, and Mr. Irby was upset that the child didn't. This is what caused the parties to be in Bartow that morning. Mrs. Irby, later that day, told a Bartow police officer that they had been to Bartow for a divorce hearing. This has been universally reported in the media. This is completely false. There was no divorce hearing on June 14th. When Mrs. Irby arrived at the summer camp with the doll, Mr. Irby was already there. Mrs. Irby threw the doll outside of the window and onto the ground of the parking lot and continued driving away. Mr. Irby, rather than picking up the doll and taking it into his child, who needed it in her camp, made the poor decision to follow his wife. It is apparent that he had more to say to Mrs. Irby. The 2 vehicles traveled 3 or 4 blocks in downtown Bartow, never exceeding the speed limits, which in that area are between 20 and 30 miles per hour. In an interview with my office, Mrs. Irby testified that Mr. Irby hit her from behind in her car. She described the first contact as a tap, the second a little harder, and the third a pushing motion for a short distance. All contact that occurred between the 2 vehicles was low, very low speed, with impact with minimal damage to either vehicle. Mrs. Irby's call to 911 revealed that she was extremely upset, justifiably scared, and likely over-exaggerating the actions of Mr. Irby. My office had a vehicle crash reconstruction expert examine both vehicles. The expert concluded that there is damage on both vehicles that is consistent with the vehicles colliding with one another at low speed. Mrs. Irby testified that the second impact caused her body to be jolted and has since experienced swelling and pain in her back as a result of the collision. Based upon the testimony of Mrs. Irby and the evidence from the expert, we have determined that there is sufficient evidence to file the aggravated battery charge against Mr. Irby, and that charge will be filed today. However, it is important for everyone to understand that contrary to what some have reported or suggested, there is no evidence to suggest that Mr. Irby tried to kill Mrs. Irby. There is no evidence to suggest that Mr. Irby attempted to run Mrs. Irby off the road. After the driving incident between the two, Mr. Irby returned to the summer camp to take a picture of the doll on the ground. And Mrs. Irby went to the Bartow Police Department. Mr. Irby was arrested by the Bartow Police Department, and Mrs. Irby then returned to the camp briefly. She then sought and obtained a temporary injunction for protection in the circuit court. In the narrative portion of that petition for injunction, Mrs. Irby explained that she was in fear of her husband because of the texting and vehicle incident from that day. She did not express any concerns in the narrative about the guns. Mr. Irby was held on no bond status until his first appearance hearing on June 15th. With Mr. Irby in jail, Mrs. Irby decided to leave the area with her children. With the help of some friends, she began to pack up her belongings. After calling into the judge at Mr. Irby's first appearance hearing and requesting that he be prevented from having firearms, Mrs. Irby continued to prepare to leave the area. One of her friends retrieved a luggage carrier from their former marital home. Mrs. Irby knew that the key to the luggage carrier was on Mr. Irby's spare keychain. Mrs. Irby decided to go with a friend to Mr. Irby's apartment and retrieve the key. This was an apartment that Mrs. Irby never lived in and had no permission to enter. Upon entering the apartment, Mrs. Irby retrieved the luggage carrier key, and because of her ongoing frustration with Mr. Irby having allegedly cleaned out a joint marital bank account, Mrs. Irby helped herself to several items inside Mr. Irby's apartment. These items include at least 2 men's watches, a GoPro, possibly a computer, items belonging to the children, and 2 guns. Mrs. Irby's friend informed my office that the purpose of taking these items was to sell or pawn them to make money. Mrs. Irby then returned to her friend's house where the packing continued. Another friend learned that Mrs. Irby had firearms in her possession and instructed the women to take them to the police department. Contrary to the reports in the media and suggestions from people who are uninformed about this case, it is our conclusion that Mrs. Irby did not go to her husband's apartment to retrieve the guns. The narrative that Mrs. Irby went to the apartment to get the guns to protect herself and her children is false. It is directly contradicted by the sworn testimony of Mrs. Irby's friend who accompanied her to her husband's apartment. In fact, it appears that taking the guns was merely an afterthought. Based upon our investigation, it also appears that it wasn't until she realized that she may be in trouble did she put forth her story that she entered the apartment for taking the guns. I have concluded that Mrs. Irby committed the crime of misdemeanor trespass. She unlawfully entered Mr. Irby's apartment, his private residence, without his permission. I am not charging Mrs. Irby with any crimes related to the taking of objects located inside the apartment. The division of marital and non-marital property is best left to the divorce judge. Mrs. Irby's unlawful entry into the apartment to obtain the luggage carrier key and other items cannot be ignored. This was potentially a very dangerous situation for Mrs. Irby and her friend. Had Mr. Irby allowed a guest to stay in his apartment, and that guest decided to protect himself or herself with a firearm when the 2 women entered that day, they could have been shot and killed. Additionally, As is common when couples are getting divorced, one party moves out and establishes a separate residence. The law simply cannot permit each spouse to freely enter the other spouse's separate residence. Divorces are already charged with high emotions, and free and unrestricted access to the other's residence could prove to be a very dangerous situation. Mrs. Irby has no criminal record. I look forward to discussions with her attorney to obtain a resolution to this misdemeanor charge, as I do with Mr. Irby's attorney as well. Now, a few words about domestic violence. Many people, some who are elected officials, have attempted to use this case as a platform to advance their own political agendas. While I'm a firm believer in people speaking their minds and advancing causes important to them, it is critically important to fully understand the facts of the situation before attempting to exploit it. While some have desperately tried to make this case about guns, folks on both sides of the issues have missed the real issue in this case. This is a case of a highly contested divorce action that has escalated to the point of both the husband and the wife being charged with crimes. Mrs. Irby is a victim of domestic violence, but that does not excuse her from trespassing and making a property grab while her husband is in jail. Domestic violence is a very serious issue facing our society. Every day, my office works hard to protect victims of domestic violence. We recognize the victims of domestic violence deal with their violence in many different ways. When we are able, we aggressively prosecute domestic violence abusers, sometimes even when the victims are unable or unwilling to testify against their abuser. I'm proud of our partnership with law enforcement as we work to protect our victims, prosecute the offenders, and look for new ways to do our job in a better way. Had Mrs. Irby just once on June 14th mentioned to the multiple officers she had contact with that she considered her husband and his guns a threat to her, her children, or even himself, law enforcement could have taken advantage of Florida's red flag law that was enacted in 2018. Pursuing a risk protection order was a possibility in this matter if only law enforcement had been informed of the need. And finally, this case and the coverage of the allegations that simply were not true has caused some to characterize our community and our local law enforcement as unsophisticated, unsympathetic to DV victims, and out of step with the rest of the state and the nation. These assertions couldn't be further from reality. I'm proud of our county, its law enforcement, and its people. You will not find another community that is so dedicated to helping those in need. We work hard to protect our DV victims. We just don't tweet about it all the time. And our law enforcement agencies are top notch. In the future, I urge those in positions of responsibility to gather all of the facts about a case before saturating the public domain with untruths, inaccuracies, and unsubstantiated inflammatory opinions. My responsibility as state attorney is to seek justice in each case based on the facts and the law in the best interests of the community. My obligation to the citizens that I serve is to do the right thing in each and every case that is submitted to my office, regardless of any political outside influences. I'm honored to work with such a great team of prosecutors, investigators, and staff. I'll be happy to take any questions.
Were you surprised? Oh, I'm sorry. Were you surprised at all when a fellow prosecutor in a neighboring county called Mrs. Irby's arrest a disgrace?
Well, I'm not going to discuss any particular comments that were made. My practice is to take care of my business in my own circuit, and I'm going to leave it at that.
Was Mrs. Irby's friend also charged with trespassing, sir?
No.
You said that friend it wasn't a boyfriend, it was a girlfriend?
That's correct. Let me also say that Mrs. Irby was surrounded by a lot of people that legitimately want to help her, and their involvement here was in the interest of helping a person in need. So I find no fault with what her friends and what her the people that helped her did.
She was facing 3 felonies, but now she's only being charged with misdemeanor trespass.
Right.
If you believe that she went into the apartment unlawfully and she took the GoPro and the watches, will you explain why she's not facing more serious charges?
Sure. I consider disputes about property between a husband and a wife that are going through divorce as a matter that is best handled by a divorce judge. In another part of my career, I actually was a divorce lawyer for a while, and people going through a divorce. It brings out the absolute worst in people, sometimes some good people. They say some bad things, they do some bad things. And if my office gets into the business of prosecuting husbands and wives who are disputing over property, I'm gonna have to hire probably 10 more lawyers that I don't have the funding for. So I think this resolution, we can't have people having unrestricted access to their soon-to-be ex-spouse's apartment or house. We've got to draw the line there, but I'm going to leave it up to the divorce lawyers and the divorce court to determine what to do with all of this property.
So you said that in this case, a risk protection order could have come into play if she had, when she went to the police, had said she feared that he was going to use the guns to harm her.
Right.
So is that something that the police should have brought up and asked her about?
Well, she had a lot of different contacts with the police that day, starting pretty early in the morning with the Lakeland Police Department. And, the risk protection order system is one that's fairly new, but if you look at the numbers, our county leads the state in risk protection orders. So there is no question that our law enforcement will use that tool if they're made aware of the situation. And so if she would have shared that with some of those officers that day, they certainly could have pursued a risk protection.
So she did file for divorce on January 2nd. She had, called police to her house in December of 2018. She said that, there was some serious, Mr. Irby was, attempting suicide, and she was, afraid. She didn't get that injunction order. It was dismissed with prejudice. And I guess her supporters would say that she truly feared for her life. There was some evidence, perhaps, that he was having these more serious issues. Do you think that the system failed Mrs. Irby in any way?
Well, I don't know all the facts of that prior injunction petition. And certainly I'm concerned for Mrs. Irby as well. I don't question that she is concerned about her safety and that she's going through a really, really tough time right now in this divorce with her husband. I know that there are a lot of tools that she can take advantage of, whether it's through the RPO process or through the injunction. She's got a pending one right now, and certainly that'll be up for the family law courts to decide. But I think it's our obligation as people in the law enforcement community, whether you're law enforcement or prosecutors, to make sure that we're doing everything we can to give information to victims of domestic violence and people who feel afraid. And I feel that we do a very good job of that here, but it's something that we're always looking at to see how we can do it better and what we might be able to do to help victims who are in need. Because when you're going through a situation like this and you feel you're in danger and your whole world is coming apart, you may not be able to think clearly and understand all the things that you probably should do. So we're always trying to be very helpful to our victims, and we're going to continue to look for better ways to do it.
Would you call this all a lie? Would you say it was just super exaggerated? What exactly, what words would you?
I think these are supercharged emotional people that are going through a really tough time, that it is now escalated to the point of them coming here and being charged with crimes. I think that it's an unfortunate situation, and it's one that I hope the criminal justice system can get resolved. But these folks, they have a long road, I imagine, in the divorce court, and they have a couple of kids. So whatever happens, if the focus is on making sure that the children are well taken care of, that's probably a good thing.
And to be clear, you still are saying that she is a victim of domestic violence.
She is a victim of domestic violence. Her testimony provided the necessary allegations and evidence, along with the expert that we hired to confirm the additional parts of evidence, and so yes, we're proceeding on the case where she's a victim.
And you are saying that on 2 occasions, she had exaggerated. One would be when she said that there had been a lot of arrests in her husband's history, but there was just 2 relatively minor incidents, and the other would be on that 911 call. Did you say that she was exaggerating slightly?
As far as what her motives are at the Lakeland Police Department that morning, whatever she was telling the officer was inaccurate. Whether it was an intentional exaggeration, whether it was a misunderstanding on her part of why she said what she said, I don't know. But I know that the allegations that Mr. Irby had been arrested multiple times, it just didn't check out. And when the 911 tape is released, it's not public yet, but when it is, you'll hear a very upset and emotional person, and I believe that those emotions were real. And sometimes when you're going through a traumatic experience like that, how you're relaying them to the person on the phone may not be exactly how you're hearing it. We recognize that domestic violence victims, they process things as it's happening to them differently, and they may not communicate as we would expect. So I don't know that it was intentional, but it doesn't match perfectly with what we concluded happened.
And on the June 14th incident in Bartow, you do believe that he followed her, but he wasn't speeding. He tapped her twice and then he hit her hard?
It's a first tap, according to Mrs. Irby, first tap, and then a second contact was where she reported feeling the pain and the swelling afterwards because of that second tap. Then there was, according to Mrs. Irby, a third where they were at an intersection and he was kind of pushing her for a short period of time. But none of this was high speed.
Do you know if any doctors examined her to confirm that she had any injuries?
That would be something that I think will come out at a later time.
Have you talked with her attorney? Do you know if she's gonna take any sort of plea? Do you have any idea what's happening there?
We'll have to let that work itself out down the road.
What's the maximum penalty for what you're charging her with?
Misdemeanor of the second degree, it's either 6 months of probation or 60 days in jail. That's the maximum. Okay.
Thank you so
Thank you all.
much.
Have a good day.